Hi, good afternoon. It's 3 o'clock on this Wednesday, January 31st in room 225. We're convening the Committee on Public Safety, Intergovernmental and Military Affairs for two agendas, one at 3 o'clock as well as one at 3:01. I got to take care of some housekeeping announcements. This hearing is being streamed live on YouTube, and if for whatever reason we have any technical glitches, we will make a public announcement as to when we will reconvene. And for those who are testifying, both online and in person, we ask that you limit your testimony to 2 minutes. So being that the first bill on the one bill on the 3 o'clock agenda is for decision making, members, if you don't mind, we'll just do all the decision making after our 3:01 agenda. And I believe it's 3:01. So we're going to move to the 3:01 agenda with Senate Bill 1392 relating to periodic reviews of detainees in community correctional centers. First in our testifiers list, we have Tommy Johnson from the Department of Corrections and Rehabilitation.
Good afternoon, Chair Wakai, Vice Chair Lafante, and members of the committee. I'm Tommy Johnson, the Director of the Department of Corrections and Rehabilitation. I'll just summarize my testimony real quick. This measure first came about, was enacted into law, I think a year to a year and a half ago. And I think it was sponsored by the Public Defender's Office and introduced by a legislator. The point was they believed that we were not doing periodic reviews of detainees' cases to determine if they could be released into the community. But we did, and as of last year, we did a total of 1,341 reviews, and none of the reviews indicated that that person's status changed, that they could be released. So let me explain a little bit what happens real quick. When someone's in custody, if any information comes to the Public Defender's Office, to the courts, or to PSD that warrants a review, we review to see if we then can request a supervised release for the person in the community. For every 10 cases we send to the judiciary, to the judge for release, 7 are denied and 3 of them do get released. As of last year, though, none of those cases rose to the level where there was an appropriate residence for them to go to, or something changed where they could be safely released. So we're asking for the measure to be repealed because we're wasting time doing these reviews, because when information comes to our attention or warrant the review, we do it anyway. This just requires us to do the review every 90 days. That's all I have. Thank you very much.
Thank you, Mr. Johnson. Kat Brady from Community Alliance for Prisons, on Prisons.
Aloha, Kat Brady testifying for CAP. We are offering comments on this because we have a big list, and it goes all over the country and even to some people in the world. And this is really what other jurisdictions are doing. So I talked with some judges, I talked with people who work at intake services at other places and said, you know, what do you do? And is this normal or whatever? They said it's really important that there be a review because many people who are put in jail are really in bad shape when they get there. Maybe they were living on the street, or they're suffering from a variety of other things. And if you give them time, then sometimes you can actually talk to them and see what it is they need. And they're finding in other places that a lot of people need mental health treatment, substance treatment, and jail is not really going to be helpful to them. So they've actually released them. So we're opposed to repealing something that was in a really good bill in 2012, 2019.
Thank you, Kat. Is there anyone else wishing to testify on Senate Bill 1392? Not members, questions? Oh, Senator Elefante.
Questions for Director Johnson? Thank you. I know in your testimony, you do support the repeal of this particular section in HRS. We did hear from Ms. Brady in her testimony of 6 months rather than 3 months, which is currently in law. So will DCR say this bill were to go through, will DCR still conduct these periodic reviews even though you're not mandated by law?
Yes, because we conduct them when information comes to our attention that warrants the review. So most of it is appropriate residence, to be honest with you. So if we find the residence appropriate, we do a report to the court and then let the judge know we found an appropriate residence. Would the court like to release the person on supervised release? If they do, if to make the courts feel safer, we'll put the person on electronic monitoring.
Thank you.
You're
Thank you, Chair.
Members, any further questions? I just have a couple of questions. Sorry for not understanding the process here. So I come in, I'm arrested.
Again?
Again, I'm a repeat offender. I come in and then this assessment is done within the first 3 months. These 1,341 reviews are done, correct?
Yes, but the initial assessment is done for a bail report to the court.
Okay,
In that assessment, then we tell the court, we recommend to the court whether they could release the person or not. And if they do, then we put them on supervised release. This bill required us to do it every 3 months, even if nothing happened with the case. We were still required to do the review. So I wanted to stress that whenever information comes to our attention, whether it's 5 days, 3 months, 4 months, 15 days, we do the review automatically to see if that changes the person's status, so we can recommend to the court that the person be placed on supervised release.
okay, now I understand. So I come in, I get my first review, then this law says 3 months, I'm up for a second review.
Pre-trial, correct.
Okay, and then can you tell me, like, one of these reviews, how, is it like minutes, how hours, how long does a review take?
The review can take anywhere from 40 minutes, well, from 20 minutes to 40 minutes, maybe 45. But if information comes to our attention, then we automatically do the review and we do a report to the court. On this 90-day review, we do the same thing, except we look at the file. If nothing new's come in, then the person's status didn't change. We still did a report and sent it to the court. And as you can see from 2023, the court denied the release.
Okay. And do you have an estimated cost on how much these reviews cost you?
Well, you take the hourly rate of the person, which verifies who's ever got the case. So you're looking from right away from $30 an hour to $45 an hour per staff person. To do, you times that by 0.5, because let's say half hour is the average, times 1341. So you're looking at tens of thousands of dollars that may be wasted doing reviews where the person's status nothing came in where the person's status changed that would warrant the person's release.
Okay. So the suggestion by Kat Brady of perhaps, okay, maybe 3 months is a little too soon, 6 months, is that reasonable? Because I mean, if we don't have that, all we do is the intake. I don't know if that's the proper term. When I first get in, I get reviewed. And then if I, for whatever reason, don't have a speedy trial and I sit there for a year, there's never a review of me till whenever the trial begins, right?
No, if any information comes to our attention that warrants the review, like a change in, like a person has a residence now, the public defender found a community-based substance abuse treatment program that would take the person in, that warrants us to do a report to the court and then make a recommendation to the court. So whether we get the information in between from the prosecutor, from the public defender's office or from the inmate, or for the detainee, we do the report automatically. If nothing happens, what we're saying is, why are we doing a report? Because we're wasting valuable staff time and resources to do a report when no new information came in to change the person's status.
Mm-hmm. I'm just trying to figure out, like, as a human, do you change that much in your behavior in 3 months or 6 months? And you're right. I mean, you're the stimuli around you isn't different, right? I'm doing whatever the daily prison routine is. So what would change me to become perhaps a better person during that time period?
I think the vast majority of things that change are, again, the family or the attorney was able to find the person a resident of treatment program. And so that warrants us doing a report to the court to recommend the court consider that person for release to the program. Or the person has an appropriate residence, now the person may not be a flight risk, and then we may request the court to consider the person for release, and then we could place the person on electronic monitoring. Those are the two main things that stop people from getting out, to be honest with you, when they have a low bail.
Got it. Okay, thank you. Members, any further questions? Yes, sir.
So in the instance where someone's condition changes, would that be an automatic instance in which there would be a reason for a report or a,
Yes, if it's brought to our attention, we would do a report to the court.
okay, so is the, I guess, typical amount of time that you may have someone incarcerated or being held, is it like 6 months, a year, or more?
It depends on if it's a one misdemeanor or felony, and how quickly the attorney can prepare for the trial. And if the attorney has information that would change the person's status, give it to us. Or the inmate could give it to us, or family member could say, hey, he can come live with us. We would get the information out, verify the residence, notify the court via a report, whether it's 5 days after they come in after we finish the assessment or 2 weeks, we would still do it. So what I'm trying to get across is that when information comes to our attention that warrants the report to the court, we do it every time. So if a report, I'm trying to get away from doing a report when no information came to our information that changes the status of the person. So therefore, we want to report on a file with nothing changed in the last 4 months. So we're wasting time and resources, is what I'm getting at. Because we automatically do the report if the information comes to our attention. But I will say this. I would agree to considering doing it every 6 months, no matter what, because then we can go back and talk to the person again. Because the detainee can always talk to their case manager and say, hey, I got an idea, maybe I got a place to go. We can cut down on the workload and we can then catch some of these things. I think that's the minimum.
Okay, thank you.
Thank you.
Members, any further questions? Thank you, Director. The next measure is Senate Bill 2543 relating to search and rescue. On our testifiers list, we have Michael Vincent from DLE.
Good afternoon, Chair Wakai, Vice Chair LaFonte, members of the committee. Department of Law Enforcement supports Senate Bill 2543. This bill actually requires agencies to seek reimbursement from individuals that are go into ignore posted warnings, go into closed areas, and end up doing something that requires some agency to now go in and rescue them. It's been discretionary, and this just makes it mandatory. We do support that. There are times when our officers are called out to help with search and rescues.
Thank you, Mr. Vincent. Rosemary Johnson from Pono Consulting has submitted commentary. B.A. McClintock has submitted testimony in support. Lynn Matisal, Julia Estigoy, Kenneth Fabrito, Lou Langford, Fabrito, all in support. Todd Yakutake is in, oh, I'm sorry, is Lou Langford Fabrito via on Zoom, IT?
Unfortunately, they're unavailable on Zoom.
Okay, I'm sorry, I skipped over Rosemary Johnson. Is she on Zoom?
Yeah, they're both unavailable.
Okay, thank you. Last testifier potentially is Todd Yakutake, has submitted opposition to the measure. Members, any questions of, we only have Mr. Vincent here. Mr. Vincent, I have a quick question.
Yes, sir.
I can never pin down the fire department as to what is the hourly cost to go send everyone up to go and fetch someone who's in peril?
I don't know. I used to know the rate of a UH-60, which is fairly substantial. CH-47 costs more, but it carries more weight, so it actually is cheaper to fly a CH-47 in a fire. It's in the thousands for the UH-60. I'm not sure what theirs would be, but I'll bet it's up there.
Thousands per hour to go.
A UH-60. So I'm not sure what their aircraft would cost.
I'm not familiar with helicopter tech, but what,
Okay,
I don't,
the
what is
military
Air
helicopter.
One, I mean, that helicopter, the fire department.
I'm not sure, but I'll bet it's pretty expensive.
Okay, that's all I want. Thank you.
Okay, thank you.
Members, we're going to go on to the bill number 3, that is Senate Bill 2693, relating to states of emergency. On our testifiers list, we have Corey Young from the AG's office.
Good afternoon, Chair Wakai, Vice Chair, members of the committee. This bill is a really good idea. It gives the state another tool in its tool chest to try and discourage this type of fraud during emergency periods. We just had a few suggestions if the committee would be inclined to follow them regarding defining the state of mind required to violate this offense. Also, taking out the specific intent that the essentially fraudster be trying to have the person rely on them, or that the intent be to have their falsehoods be relied upon. It's simply just too easy for someone to take the stand during a trial and lie about what they were intending to do. Our point would be their actions speak clearly. They're lying, they're trying to get money. What does it matter what they're going to say about why they were trying to do it at that point? As far as the bill goes, we were looking at it sort of like a theft by deception, but just specialized for the emergency periods. And we were wondering if the committee were inclined to either bump up the penalties, make it non-deferrable, or potentially attach other penalties like mandatory jail. At this point, the penalties you'd be looking at for this offense would be not different from like a standard theft by deception. So if you are inclined to treat it more harshly, that would be something for the committee to consider. I'll be around for any questions. Thank you.
Great, thank you, Corey. Jacob Warnick from the Hawaii Young Republicans has submitted testimony support. Julia Kahaone has submitted testimony support, as well as Thomas Chang also in support. Is there anyone else wishing to testify on Senate Bill 2693? Members, any questions? Mr. Young. Sorry. Sorry for my lack of legal understanding, but when you say with regard to the penalties, non-deferrable, what exactly does that mean?
Usually if someone commits a crime and they're a first-time offender or don't have an extensive record, they can ask to have the matter essentially deferred. What the court would do is put them on certain terms and conditions, basically exactly like probation, except at the end of the deferral term, they would be eligible to have the matter expunged from their record. To get a deferral, though, the court would have to find that the person is unlikely to reoffend and that basically the interest of justice do not require that this person have a conviction like this on their record. If the committee were to make this non-deferrable, what the committee would basically be saying is, we believe that a conviction for something like this should not be wiped off your record. We believe that this is a serious enough type of offense where the court should not be making a finding that the interest of justice can have someone wipe this off their record. We want people to be able to like see who's done something like this, who's engaged in this kind of fraudulent activity during a state of emergency.
I understand that. And then you said that, I mean, do we want people to go to prison for doing this?
That's up to y'all.
I talked to my fellow members here. I'm not too sure we want to clog the prison up with folks. Thank you. Any further questions? Thank you, Corey. The next measure on our agenda is Senate Bill 2910. And this is relating. Oh, am I on 9? Oh, sorry, I skipped ahead. 29. Oh, yeah. Yeah, 2909. Sorry, it's not on my testifiers list. Relating to emergency management. And, oh, I know why. We don't have anybody testifying. That's why there's no testifiers list. Members, we have no testimony on 2909. So if you don't mind, we're going to move on to 2910. Relating to the. Oh, that's right. Forgive me, members. On the previous bill, 2543, we have Rosemary Johnson joining us via Zoom. So I apologize if you could indulge me. We're going to go back to 2543 since she was queued up to testify on this bill, which was about the search and seizure bill. Search and rescue, not search and rescue bill. Rosemary, welcome.
Thank you. I appreciate you going back to allow me to testify. Mahalo, everybody. just a little bit about who I am. I'm a retired engineer and a Six Sigma black belt for Fortune 15. I've currently been a strategist, and I've been involved in the production of the first and only search and rescue conference in the state of Hawaii. That is the only platform in the state which brings together all of the latest tools, technology, and training for all emergency services, public safety, and search and rescue agencies, as well as civilian volunteers. It built a foundation where relationships and communications can be enabled for everyone to work together more effectively and efficiently to save lives. So I have just a little bit of experience with data collection as well as search and rescue in the state of Hawaii. I was only making comments on the last bill. Prior to the August 8th fires, I was interviewed, and there is a post on my LinkedIn from about a year ago. In July of 2023, there was an article published in the leading international search and rescue source named SAR Wilderness. That was distributed throughout the Capitol building. On August 9th, I gave a presentation at the Capitol with regards to resources or the lack thereof for search and rescue within the state of Hawaii. On January 3rd, there is Rescue Ronin. They have a podcast, and they did a podcast on SAR in Hawaii. All of these things explain a critical factor about safety and prevention to our residents and tourists in the state of Hawaii. There is this bill as well as other bills that are in session right now. And there is one critical factor that everyone needs to know about this, is that yesterday there was a bill passed for the silver alert. Hawaii is one of the few states in the country without a silver alert. So that was a great stride in the right direction. Hawaii is also one of the few states.
Can you summarize, please?
Yes, I am. Hawaii is one of the few states in the nation without a SAR system. That means that we have no state SAR coordinator. We have no state SAR written plan. We have no state SAR budget, and we have no state SAR board to distribute the budget. Therefore, enforcement as well as implementation of these bills are always going to fall short unless we implement those critical items. First,
Okay.
starting with a state SAR coordinator. Thank you for your time. Any questions?
No, thank you, Ms. Johnson. Your commentary had nothing to do with this bill, but I understand your concerns on other issues regarding public safety.
Well, that is for that particular bill because it is not, as far as
Okay,
implementation and enforcement,
Got
it's
it.
going to be very hard to collect anything there.
Sure. Thank you, Ms. Johnson. Appreciate
Okay.
it. We're going to move on to the next measure, which is 2910. Get back on track. On our testifiers list, we have Mr. Vincent from DLE.
Good afternoon again. The Department of Law Enforcement strongly supports this measure. This measure is to provide funding and positions for 15 full-time deputy sheriffs to support Maui, primarily in the Lahaina area. This is really new. We reached out to County PD, Maui PD, and during the recovery and rebuilding, they're going to need law enforcement presence in the area. And this is a good way to help get that presence in there without overtaxing the county police officers. But one of the things that really helps the department is it helps us for our long-term planning to eventually be able to put more officers on the island and in the airport over there. So in our 3 to 5 year plan, they're all going to be on the island, and it'll be easier to move them into there for our long-term planning. So it kind of kills two birds with one stone. Thank you very much.
Great. Thank you, Mr. Vincent. Tim Kozak from the judiciary. Oh, I'm sorry, I'm looking at the next measure. Alan Urasaki has submitted testimony support. Michael Older in opposition, and Kerry Shiroto from ACLU has submitted commentaries. Is there anyone else wishing to testify on 2910? If not, members, any questions? Yes, Senator Elefante.
Thank you, Chair. Questions for Mr. Vincent? Thank you.
Yes, sir.
So currently now in the Lahaina area or on Maui, before the transition into DLE, was there any sheriffs or positions there?
The only sheriffs on Maui right now are in the courthouses, and we have one at the harbor.
And then I understand in your testimony that the request is for 15, 11 deputy sheriffs and 4 admin. Is that
The
correct?
supervisors, so that would be like the sergeants and the lieutenant. It's,
Okay.
you've got so many at DS2s and then you need some supervisors over there. So that's
Okay.
why the differential.
Okay, thank you.
No, thank you.
Any further questions, members? Okay. We're going to go on to the last measure on this agenda. That is Senate Bill 3009. It's relating to the Department of Law Enforcement. On the testifiers list again, Mr. Vincent. Oh. Jared, sorry.
Yes. Good afternoon, Chair Wakai, members of the committee. My name is Jared Ridula. I'm the Deputy Director for Law Enforcement with the DLE. This afternoon, the department is in very respectful opposition of the bill. We aren't in opposition over necessarily the content of the bill. However, we believe that the contents of the bill are already achieved in current existing statutes. The current existing statute in Chapter 353C, for example, already lays out the responsibilities of the Department of Law Enforcement and its officers, as well as the powers and authority that those officers have to include enforcement of the law in legislative buildings, judiciary buildings, facilities, and grounds. As well, the second portion of the bill, which goes towards accreditation, is already an existing statute where it already state law requires us to achieve accreditation for our sheriff division. This said, the DLE is pursuing accreditation for all of its newly combined the 5 other law enforcement units within the DLE. And in seeking that additional accreditation for the entire law enforcement structure, we have additional vehicles in the legislature to assist us with achieving accreditation for all of the other law enforcement units as well. So thank you very much for the opportunity to testify.
Thank you, Jared. Tim Kozak from the Judiciary.
Good afternoon, Chair, Vice Chair, Committee. My name is Timothy Kozak. I'm the Special Assistant for Judiciary Security with the Judiciary. Been in that position 6 years. Prior to that, I was a special agent with the United States Secret Service for close to 30 years. Our testimony has been submitted in writing. I have a few highlights I'd like to share, and then I'm available for questions. The Judiciary strongly supports this measure, and in summary, want to note that it is common and best practice for a state to have specific statutory authority for a law enforcement agency outlining responsibilities for providing a law enforcement presence in that state's court system or judiciary. Further, the judiciary knows of no other state other than Hawaii that does not have some sort of specific statutory language for a law enforcement agency to provide responsibilities to our courts. The sections in this bill that specifically address the judiciary are common and best practice for executive branch law enforcement agencies that provide a protective and security mission to judiciary branches of government. The judiciary is required to meet the common national best practices based on the guidelines established by the National Center of State Courts for providing court building security. These best practices have been prepared and are consistent with recommendations from the International Association of Chiefs of Police, National Sheriff's Association, the United States Marshal Service, Homeland Security, Transportation Security Administration, Conference of Chief Justices, Conference of State Court Administrators, and National Association for Court Management. Finally, the section of this bill that addresses partnering with the judiciary is also common and best practice and mirrors the statutory language of the United States Marshal Service, which outlines that the Marshal Service shall consult the Judicial Conference of the United States on a continuing basis regarding the security requirements for the judicial branch of the United States government. The judiciary strongly supports the adoption of the language of this bill for the above reasons. In addition, the judiciary is very excited with the creation of the new Department of Law Enforcement and stands ready to support the new department to assure that they can become one of the best law enforcement agencies in the United States for providing protective and security services for the courts. Thank you, and I'm available for questions.
Thank you, Mr. Kozak. We have Alan Urasaki and Victor Ramos, who have both submitted testimony in support. Is there anyone else wishing to testify on Senate Bill 3009? Members, any questions? Oh, Senator Rhodes.
Can I start with DLE? So this is a common occurrence at hearings where somebody says, well, we're already doing that. Because it's kind of a double-edged sword. So it's like if you're doing it already, then it doesn't really matter whether we pass a bill or not. If you have the statutory authority, then no skin off your back because you're already doing it. Is that not correct?
I could see your point, Senator. I think with this particular bill, in the preamble to the bill, it talks about making sure that legislative and judicial security or law enforcement support is the core mission of the Department of Law Enforcement. And I want to be clear. We certainly understand the importance of that mission and providing that service. Amongst the other equally and sometimes very important other priorities that the legislature has also set out for us. For example, the enforcement of fireworks through our task forces and things like that. We have to make sure that the economy of resources that we have are divided in a way that can meet our department's priority and goals. So I certainly understand what you're saying.
But isn't protection of the judiciary and the legislature, haven't they always been your core missions?
So traditionally, in the from decades long ago, yes, we have always provided that mission, and it continues to be a large part of the mission and resources that we have dedicated towards that mission.
Okay.
We have always embraced that mission.
Okay.
But in 2024, our missions have also evolved where we've had to take on other law enforcement tasks as well.
Okay. All right. Chair, can I ask a question, Mr. Kozak, too?
Yeah, of course.
Mr. Kozak, can I come back up? Thank you. Appreciate it.
Sure.
But maybe you can just stay here.
Oh, okay.
Because
Sorry.
We have questions for both of you.
So I guess I'm a little, the timing of the bill is interesting. So is something happening at judiciary that prompted, I mean, it's not your bill, it's not the judiciary's bill, but is there something that prompted your support for this kind of bill at this particular time?
We have been involved in discussions with DLE for some time. And there have been some exchanges of information that have particularly made us concerned regarding the transition to the new department and their new mission. And there were some plans originally planned for reductions of staffing in our courthouses. And we have seen some reductions of staffing in our courthouses.
Okay. All right. I think that's what I wanted to know. Thank you. Thanks, Chair.
Sure. Senator Elefante.
No, the Senator from Chinatown asked the questions I had. Thank you.
Any other questions? I have a question. Because I want to understand the need for this measure. So, Tim, is it correct that one example is where there was training by sheriffs that needed to be done? I can't remember, it was 5 or something that were removed from the courthouse, which left you and the judiciary scrambling, like, how am I going to do the processing of these court cases? Because the sheriffs are now in training and without, I don't know what kind of prior notice or if any was given. Is that an example of where this law would help you to ensure that you're fully staffed with the right law enforcement personnel so the judicial proceedings can move forward?
I don't understand your reference and really what, are you talking about a specific event? Because I don't
Is
know
that true?
about that
Like,
event.
somehow someone told me that you guys had training and you just yanked a whole bunch of sheriffs out of the courthouse.
Senator, I don't know of any specific instance
Oh.
like that.
I do understand now.
So Senator, I don't know of any specific instance like that. What I would say in terms of that is, so these kinds of situations, my sense is we shouldn't have to settle this with the law. Let's settle this by talking and shaking hands and figuring out beforehand, hey, we have a situation where we need training. How do we solve this? And let's get together and talk and solve this without the need to codify this in statute. So I'm not saying that a situation like that didn't happen. I'm not aware of a specific situation like that didn't happen. But I think that through communication and management, we are able to solve this. And I think I will stand before the committee now and say that I'm committed towards open communication with the judiciary and the legislature to ensure that these kinds of shortcomings, if they are occurring, don't occur, and that we can meet and find common ground to make sure that the services that we provide are satisfactory to our customers, and we can meet our mission and our obligations for training and getting the other law enforcement taskings that we have to do done as well. So I think in terms of working together, we're committed to it. And I also think that there was parts of the law that talked about filing annual reports and those kinds of things, and we certainly can report back to the legislature the kinds of progress that we can make together. But I think, again, that these sort of issues, if they occurred in the past, and to be fair, I was never a member of the Sheriff Division, I was the Narcotics Enforcement Chief. So I don't know specifically if these types of situations occurred. However, we're committed to making sure that we are working together and that we can solve this.
What happens when the administration changes and you retire? Sorry, I was gonna say George Washington, but Jordan Lowe retires. Then what? Then the judiciary, perhaps the next crew comes in, has a very different view on their interaction with the judiciary.
I certainly can understand that. I think it's necessary for us to set up a culture of open communication. That's why I'm saying I start now, Tim, and come before this committee and say we need to start talking so we can solve this without the need to have to pass a law saying go settle differences. Part of our mission is not only to provide these law enforcement services, but to ensure that we have good customer service. The legislature and the judiciary are certainly our customers.
Do you have any comments on?
I do, and I do know what you're referring to, and I can say without doubt, we have a great deal of examples, and they specifically come from national best practices addresses that there should be a minimum staffing level identified for each courthouse. That is not identified. And as a result of not having those minimum standards identified, they operate much below national best practices at times due to leave, extended leave, and training dates. And we have extensive records to talk about that. We've addressed their leadership with these issues. We've been talking to them for 2 years about these issues. Our communication is very open. I come from a culture of law enforcement as a Secret Service agent that you can't protect anyone without the cooperation of law enforcement. So I have been involved in cooperating amongst law enforcement agencies my entire professional life. And I welcome that and will always welcome that. But we feel strongly these measures are important.
Thank you. Members, any further questions?
I did have one further
Senator
one.
Rhodes?
Thank you. For Mr. Kozak, do you, independently of whatever, of what we've been talking about, do you monitor the threats or incidents at courthouses or against judicial personnel?
I most certainly do, and I
Is it-
have detailed records.
Has it increased in the last?
Yes, I have a graph that I can share with you. Let me get that for you.
Yeah, I don't mean to belabor the point. That was my main question, was whether it's gone up. Well, it's your committee. If you want it, it's yours.
Oh, you want the statistic? Oh, so they're not copies.
Okay, I'll give it back. I'll give it back.
With everyone
Okay,
after,
okay.
You take a look at it.
Okay, that was all. Thank you very much. Thanks for the graph.
Oh, any further comments, questions? If not, thank you, gentlemen. We're going to take a brief recess. Thank you for your patience. We're reconvening the Committee on Public Safety, Intergovernmental and Military Affairs. We're going to go first to our 3 o'clock agenda. This is a measure we took up last week, members, but in putting the committee report out, it was pointed out from WHAM, there's a new way of doing things for them. So if you indulge me, I'd like to revisit this measure and share with you the amendments that we're going to take. Because we're in the second year of the biennium, we're going to change it from a 2-year pilot project to a 1-year pilot project. And we are going to take out the appropriation and put in the committee report that it's recommended that WHAM find $50,000 for this measure. And we're going to defect the date, making it effective January 1st, 2042. Members, any questions? If not, Senator Elefante, I vote yes.
Chair's recommendations to pass SB 2094, reconsidering its previous decision on the measure with amendments. Chair votes aye, Vice Chair votes aye. Senator Fukunaga.
Aye.
Senator Rhodes.
Aye.
Senator Awa.
Aye.
Mr. Chair, recommendations adopted.
Meow. Okay, next measure. Oh, we're on the 301 agenda now. On this agenda is Senate Bill 1392, relating to periodic reviews of detainees in community correctional centers. Members, I'd like to pass out this measure with the amendment suggested by Kat Brady and her prison group, which would be to change it to having these reviews done in 6 months rather than in 3 months, as well as some technical non-substantive amendments. Any discussion? If not, Senator Elefante, I vote yes.
Chair's recommendations to pass SB 1392 with amendments. Chair votes aye, Vice Chair votes aye. Senator Fukunaga.
Aye.
Senator Rhodes.
Aye.
Senator Awa.
Aye.
Mr. Chair, recommendations adopted.
Thank you. On the next measure, Senate Bill 2543, relating to search and rescue. I'd like to pass this measure out with technical non-substantive amendments, as well as making the effective date January 1st, 2042. Any discussion? If not, Senator Elefante, I vote yes.
Chair's recommendations to pass SB 2543 with amendments of the 5 members present. Any no votes or votes with reservations?
Reservations.
Noting the reservations from Senator Rhodes, Mr. Chair, recommendations adopted.
Okay. On the next measure, Senate Bill 2693, relating to states of emergency. This is to help fight bad actors in times of crisis. So we'd like to go with the AG's suggested amendments. I'm just going to highlight the 3 parts of their suggested amendments. We're going to define state of mind. We are going to delete the any reference to direct, the word direct in the subsections that are outlined by the AGs, as well as we're going to use their definition of solicit and solicitation for this. And also going to take up their suggestion that if you're convicted of this crime, you cannot have it deferred. It's going to stick with you for the rest of your life. So those are the suggested amendments. Any discussion?
Yeah, reservations on that one too, on the deferral part of it, but it's fine. I'm not,
So if I take that out, you're gonna say yes?
Yep.
Oh, okay, we'll take it out. We'll let somebody else figure it out. Okay, so, sorry, members, again, we're just gonna take the AG's suggested amendments, the ones that are outlined in their testimony, that I mentioned, the three areas. And forget the deferral, suggestion I had mentioned, because I want to make everyone happy. Any other discussion? If not, Senator Elefante, I vote yes.
Chair's recommendations to pass SB 2693 with amendments of the 5 members present. Any no votes or votes with reservations? Hearing none, Mr. Chair, recommendations adopted.
Thank you. The next measure is Senate Bill 2909 relating to emergency management. Considering we had no testimony on this bill, I would like to defer that bill indefinitely. For 2910 relating to the Department of Law Enforcement, this is where we're going to have proposes 15 temporary positions in Lahaina. And I didn't realize we had only sheriffs in the courthouse and one at the harbor. I didn't realize there were so scant few sheriffs we've had on that island. So I'd like to actually take up the Department of Law Enforcement suggestions that these 15 full-time employees become hopefully permanent, if we can find the money, permanent full-time employees there. So making that amendment okay, asking, I'm trying to make sure I'm good with WAM. We don't have any figures in here, right? So I think there's it's already no appropriation figure in there, so we won't put anything in the committee report. Okay, we're gonna make the defective date January 1st, 2042. Any discussion? If not, Senator Elefante, I vote yes.
Chair's recommendations to pass SB 2910 with amendments of the members present. Any no votes or votes with reservations?
no.
No vote for Senator Wah. Mr. Chair, recommendations adopted.
Okay, thank you, members. On the last bill, Senate Bill 3009 relating to the Department of Law Enforcement. I know that there are hopefully better days between these two agencies, being the judiciary and the Department of Law Enforcement. But as we heard from the judiciary, that they would like to have something in statute. So Hawaii aligns with many other states in terms of what the expectations are from the law enforcement side of things in the protection of our judges and personnel in the judiciary. So I'd like to pass this measure out with technical non-substantive amendments and defective date to January 1st, 2042. Any discussion? If not, Senator Elefante, I vote yes.
Chair's recommendations to pass SB 3009 with amendments of the 5 members present. Any no votes or votes with reservations? Hearing none, Mr. Chair, recommendations adopted.
Thank you, everyone. We are adjourned.